Welcome, everyone, to the Flowing Through SoCal video podcast. I have with me today Wayne Rosenbaum again to speak specifically about the recent Supreme Court of the United States decision related to the Chevron Doctrine. So with that, Wayne, I think I just want to kind of dive right into this and tell me a little bit what happened here with the Chevron decision, maybe just a little bit of background on what it was and then what it means.
Sure. The Chevron Doctrine goes back to the 1980s. And what the Chevron Doctrine says is that the courts will defer to the agency in terms of the agency's interpretation of their authority under a statute based on the agency's expertise. So Chevron said, as an example, look, Congress wrote the EPA wrote the Clean Water Act. They designated EPA and the delegated states to implement the Clean Water Act. EPA and the states have the expertise to implement the Clean Water Act, and therefore we will defer to the agency's interpretation of its authority under the statute. What this court said in a case called Loper-Bright is, no, hold on a minute. The purpose of the judicial branch is to interpret the law. The purpose of the administrative branch or the executive branch is to implement the law. And we are not here to, it is not appropriate to defer to an agency regarding how to interpret a statute. The end result of this then becomes, what we're really saying is, okay, the courts are now going to step in and say, what does the Clean Water Act really say, and what kind of authority does the Clean Water Act really grant to the agency? And this is going to have some significant impacts because over a period since the 1980s, we've just kind of assumed, or the courts have just kind of assumed, because the agency says so, they have the authority. And in a couple of other cases we'll talk about, maybe the court in this session, the court kind of said, hey, nah, we're not going there, and there may be injured parties may have a right to look back and say, wait a minute, EPA never had that authority in the first place. So that's the real take home of Loebner. But it is also moderated by two other cases, one called Skidmore and the other called Auer. And what Auer and Skidmore really say is, once the agency has adopted appropriately adopted a rulemaking, a regulation, then we are going to grant the agency a greater level of deference as to how that regulation will be implemented. Because they say, yes, if the agency can demonstrate it has the expertise in a given area, then that's now more facts than law, and we, the courts, will continue to defer to the agency in terms of how to implement it. Some examples might be, as you know, right now, the agency is wrestling with their residual designation authority under the Clean Water Act, and whether or not what the scope of any additional group of regulated entities could be under a new permit called the CII permit. And it now becomes a two-step analysis. One, did Congress really grant the authority to the agencies to include in this scope of regulations things like churches, cemeteries, monasteries, private schools, mixed-use housing developments? Was this part of their, did Congress delegate that authority in the first place?
Right.
The second step then would be, assuming that, and that's really the Loebner analysis. The second step would then be under our and Skidmore, hey, assuming you were delegated the authority to regulate these entities, are you doing, while we will grant you deference to use your expertise, can you demonstrate that you have applied your expertise appropriately in terms of your decision to regulate them? Again, examples under that permit. Why 5 acres versus an acre? Why private schools but not public schools? Have you used your authority in a way that is appropriate? And that's going to be the second test. What's it mean for the agencies? Well, I think what it's going to mean at the end of the day is they're going to have to be more careful in dotting their I's and crossing their T's. That they are really going to have to work through the science and the facts rather than because I say so. The implications, as I see it, are one, I don't believe they have the resources or the expertise to actually do a lot of that. The last time we tried that, again, I'll give you another example. At one point in time, under the federal industrial permit, which we call the MSGP permit, stormwater permit, they began to go through that analysis in terms of various industrial groups and started saying to things like cement kilns and steel mills, okay, we're going to establish discharge limits, which we see in our permits, because we're going to go through that whole process. The realities were they've got through what, maybe a dozen of these groups, these SIC codes. They looked at the other 400 odd SIC codes and didn't seem to have either the will or the money to continue on down through that process. And so I think you're going to see agencies being much more constrained in terms of how broadly they cast their net. I got to do it right. I can't just, make the assumptions that we've made today.
Right. So let me ask you this. So as a water rights attorney, do you expect to see a lot more litigation post Chevron doctrine than what you would have previously seen?
Yes, for a couple of reasons. First of all, this change in course under Loebner is really fairly dramatic, and so I think that anybody who is going to appeal any action of a state or federal regulatory agency will throw Loebner or Chevron into the argument, saying you never had the authority in the first place.
I see.
And this is sort of, that requires then somebody on the other side and then the courts to go through the analysis. Well, did the statute really grant the agency the authority the agency is saying they have? That's going to be a lot of work. The other problem is I think we're going to see major conflicts in interpreting Loebner. You get a district court in Hawaii and a district court in San Diego, and district court in Hawaii interprets a statute, a regulation one way. You had the authority, and the district court in California, because they're both part of the Ninth Circuit, says no, you didn't. And all of a sudden now you got a split between between the districts, so it goes up to the Ninth Circuit, and the Ninth Circuit rules one way, but the same issues are being raised on the east, in the south under the 11th Circuit. The 11th Circuit rules another way, and so this all gets up to the Supreme Court. And this is exactly what the dissent in Loebner was saying. Guys, you open this Pandora's box without all the necessary guidance, and it's going to be a litigation holiday.
Right. You talked a little bit about how this will affect RDA for the CII permit, which was the commercial, industrial, and institutional permit that was in draft form for 2 watersheds in Los Angeles. How do you see this affecting the PFAS regulations. There's a zero point 0.7, I think, PPT drinking water limit, and there's all this movement around PFAS. How do you see this post Chevron universe looking with respect to PFAS?
Well, okay, the PFAS rulemaking had already been appealed by several groups prior to in the DC circuit, DC court,
Okay.
saying, "Hey, it's arbitrary, it's capricious. You don't have enough information to back these numbers. You pull them out of your ear. This is not an appropriate rulemaking." I expect that we're going to see all of those petitions now be amended to also say, and oh, by the way, Congress never gave you the authority, EPA, to regulate PFAS compounds in this way. You know, maybe you have the authority under TSCA, maybe you have the authority someplace else, but Congress never delegated this authority to you in the first place. I'm not sure how good that argument is, but I am very sure that that argument will be made. And again, because this is essentially a new doctrine, I do expect that this will be appealed up to the Supreme Court, which will continue to stay the PFAS rulemaking, the PFAS rulemaking under the Drinking Water Act for quite some time. So I think in a lot of cases you're going to see delays.
So if I'm a small water district and I'm getting ready to put in a PFAS treatment on my wellhead to remove PFAS down to the PPT level, before I spend millions of dollars on this treatment system, I may want to know whether or not I have to do this or not. So in that situation, are you saying that the legal argument may be that the EPA never had the authority in the first place to set such a limit?
Well, okay. Putting aside groundwater supply companies, because they are unique, because of the litigation in North Carolina, where they've already entered into settlements with DuPont and 3M and Kinney, and so there's a pot of money there for that. I don't think it's a big enough pot of money, but at least there's a pot of money. I don't think those folks are going to say, no, I'm not going to take the money and I'm not going to build these systems. Whether or not I'm going to maintain these systems into perpetuity and the costs associated with that may be an issue for another day. But if I look at some other folks, if I look as an example at an industrial facility, and I say, oh, wait a minute, I now have a water quality standard, a receiving water limitation, not a limitation, but a water quality standard in the parts per trillion range. What should I be doing? How should I interpret this? Because in their case, hey, I think, and we can talk about it a little bit differently in a second. I would say to them, hey, do what you think you need to do for about the next 10 months. And the reason I am saying that is when we talk about the issues in terms of receiving water quality, which is unlike drinking water on the other side, but receiving water quality, then the question of the city and county of San Francisco v. EPA comes up,
Right.
which is a case to be decided in the next term of the Supreme Court.
Yeah, give me a little history on that. How did that start, and how do you think it's going to end?
Badly. No. How does it start? Well, okay. The city and county of San Francisco have several combined flow sewer treatment systems, and they were seeking to renew their NPDES permits for these treatment facilities. In doing so, the regional board and EPA insisted on a provision that said, thou shalt not cause or contribute to the exceedance of a water quality objective And by a water quality objective applicable to you facilities, we mean the water quality objectives for the Pacific Ocean.
Hmm.
Bacteria, the pesticides,
Everything,
everything you can
everything.
imagine. Okay.
Right.
And what the city and county said is, nah, hold on a minute. That's not an appropriate standard to impose on us. EPA and the regional board said, watch us. And they sued the city and county to enforce the permit provisions in federal court, in the district court.
Okay.
At that point, uh, the city and county refined their argument and said, wait a minute. The Clean Water Act has a process by which one determines what the effluent limitations should be to achieve receiving water standards. It's Section 300 of the Clean Water Act. We're going to establish 303D impairments, and from the impairments, we're going to define TMDLs, and based on the TMDLs, we're going to allocate mass loads, what I sometimes call ration tickets. And so you facility are going to get X pounds per year, which then gets typically converted into a concentration. You haven't done that, said the city and county. What you've done is you've just skipped around it and said, don't cause or contribute to the exceedance. And the city and county are saying that's not how the Clean Water Act works. So they lost at the district court level. They went to the Ninth Circuit. They lost at the Ninth Circuit, and they appealed to the Supreme Court.
Okay. So that's where it sits right now.
Right.
Okay.
And so the question is, well, what would you predict? Well, first of all, the Supreme Court takes as you know, a very limited number of cases that the people seek the Supreme Court to hear. Yeah, I think it's something like 4% of all, 4% of all the cases that get filed every year that they even decide they're going to take.
Okay.
So clearly, if they decided to take this case, they were going to do something with it.
Okay.
And looking at this Supreme Court, I think they will. And looking at the amicus briefs, there was an amicus brief filed by several hundred of the other wastewater treatment plants across the country saying, this is nuts. This is the way the Clean Water Act is supposed to work. This cause or contribute thing is bogus. And then there was another amicus brief filed by the Mining Association, the National Chamber of Commerce, the oil and gas, all the major industrial and lobbyists, and they were supporting the same position that says the way the Clean Water Act, unlike its predecessor, the Rivers and Harbors Act, is supposed to work is you the regulators, are supposed to go through a process that results in a number that is sufficiently protective of the receiving water. Till you do that, you can't just say don't cause or contribute. Why do we care? Well, we care because anybody who has an NPDES permit, open your permit and it says thou shalt not cause or contribute to the exceedance of a receiving water limitation or a water quality objective. And the end result, and we've seen a bunch of third-party citizen litigation over this issue. And so it's really an important issue to be worked out. How do I think, assuming that I'm correct and the Supreme Court says, oh, you guys, all you petitioners, you're right, EPA, you're wrong. And again, given the more recent cases we've seen from the Supreme Court, I would give a high probability that that's the way it's going to come out. Then it really changes, one, how our permits, our water permits, whether it's stormwater permits, NPDES permits are constructed. And two, it pushes back to the agency the obligation to perform their duty, which is after you've identified a 303D impairment, which California is very good at. Okay,
yeah, we have lots of
them. Water in the state that isn't 303D impaired. Right. If you want to regulate the discharges to that water, you have to establish a TMDL. And then you have to translate that TMDL into a permit requirement. So if they conclude that, whatever river has an assimilable load of 4 pounds of copper per year, they then have to take that and implement it through the permit process, which requires them to go the next step that says, well, the total assimilable load is 4 pounds. Who gets the ration tickets? Is it a MS4? Is it an IGP? And this is going to be a process that's going to take a significant amount of time and resources. And so I think if I'm correct, I think the outcome will be that we will see much less of this broad brush approach. Don't just stand there, do anything, and more of a very targeted approach where the agencies are going to have to use their resources in a way that gets the biggest bang for the buck. And I don't think that when they do that analysis, even with all the political hype and pressure, they're going to say, PFAS at 0.4 parts per trillion is more important than copper or zinc or 6-PPD or some of these other compounds where they really know that there is a potentially significant impact to human health and the environment.
I see. Wow. Well, I'll tell you, this is amazing stuff. It's an interesting time to be in the water space for sure. Wayne, I really want to thank you today for explaining this to us, and I think the implications are going to be far-reaching. We'll make sure that we reach out again and get an update on this as we move forward. But again, thank you so much for joining me today, and we'll see you next time.
Hey, thank you, Sean.